Hello and welcome. I am Professor Rashmi Raman and this is Module 19 of International Criminal Justice. This module is on criminal procedure and sentencing. As always, let us first discuss the learning outcomes. The importance of the rules of procedure in international justice is the first learning outcome in this module. I would also want you to understand what are the specific rules of procedure that govern the proceedings of the international criminal tribunals and courts. And finally, for you to understand procedures regarding sentencing in international criminal justice. Criminal proceedings, be it domestic or international, are governed by procedural rules. In international criminal courts and tribunals, procedural rules govern the action not only of prosecuting authorities but also provide safeguards to the accused, and they list the framework of the trial, which means that the trial just fits neatly into a prescription made by the statute. Procedural rules are also important because they provide guidance for the sentencing of individuals who have been found guilty and convicted by international tribunals and courts. International criminal procedure therefore cannot be said to be a body of law which exists by itself. Instead, the procedure is to be found in the rules of procedure and in the rules of evidence of the international criminal courts and tribunals and the practice that is reflected in their decisions. International criminal procedure rules, due to their international nature, are composed of rules that are different from the rules of procedure in a domestic legal system. There is an interesting fusion of procedural rules that borrow from different legal traditions. This is not easy to achieve as there are significant differences between the two major legal traditions, that is common law and civil law, especially when it comes to procedure. International criminal procedure has therefore evolved in a very unique manner. Unlike the rules on jurisdiction, admissibility or the applicable law, which are provided for in the statutes of the courts and tribunals created by the international community, procedural rules are left for the judges to agree upon. As we have seen in earlier modules, international criminal courts and tribunals are born out of political considerations, and very often their birth is a political compromise. Their statutes are predominantly decided by negotiations between diplomats who are not necessarily experts in the field of international criminal law. Thus, they leave details like rulemaking on procedure and evidence to be formulated by the judges of the courts and tribunals as and when these issues come up before the courts and the tribunals. The statute of the international military tribunals in Nuremberg and the military tribunal for the Far East in Tokyo had a few procedural rules. The judges of those two tribunals came up with the procedural rules in the course of hearing the cases. These are judges with vast experience in domestic jurisdiction. Likewise, when the Security Council established the ICTR and ICTY, it also provided very few procedural rules. The statutes of both the ICTY and the ICTR state that judges of these two tribunals would adopt rules on procedure and evidence. A notable deviation to this practice is the International Criminal Court, where the Assembly of States Parties adopted the rules on procedure and evidence. While the international criminal procedure codified encompasses a lot of principles, for the purposes of this course, we will be looking at procedural rules regarding the rights of the accused and the idea of sentencing. The rights of the accused recognized under international criminal law reflect the fundamental rights recognized in international human rights treaties, such as in the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social and Cultural Rights, the European Convention on Human Rights, the Inter-American Convention on Human Rights, the African Charter on Human and People's Rights, and the Declaration, the Universal Declaration of Independence. An important feature of trial is the independence and impartiality of the tribunal. This is one of the fundamental principles of human rights, recognized as such in common by all the treaties that I have listed above. This principle also exists in domestic laws throughout the world almost uniformly. An independent court, or as in this case, a tribunal, has to maintain functional as well as institutional separation from the states who created it and the executive and legislative prerogatives assigned to it. The manner of creating international courts and tribunals often raise a doubt about their independence. For example, the international military tribunals for Tokyo and Nuremberg were created by the victorious powers of the Second World War. Ad hoc tribunals have been created by the powerful Security Council. However, procedural rules guarantee that the creators and funders of these tribunals are not able to influence the outcomes of individual cases, which must be decided according to the applicable law and on the basis of evidence presented in an applicable case. Additionally, the exercise of jurisdiction of these tribunals is often based upon cooperation by states. Therefore, it becomes important to ensure that the rights of the accused are not compromised while availing cooperation. There are also procedural safeguards to ensure that the accused is tried by an impartial judge who must be personally as well as institutionally impartial. The appearance of bias has led to the disqualification of more than one judge from cases before the courts and tribunals. In response, the ICTY Appeals Chamber has come up with a standard for the assessment of impartiality of judges in the Furunzija case. In that case, the ICTY stated that if a properly informed, reasonable observer is led to reasonably apprehend bias due to certain interests or circumstances of a judge, then that reflects the partiality of the judge and the judge must therefore be disqualified. Judges may choose to recuse themselves from cases if they already admit that they are biased. The Rome Statute of the ICC addresses the requirement of impartiality and independence of judges and the prosecutor in many provisions. The judge and office of the prosecutor is required to function completely independently. The accused also has a right to an impartial hearing. While the Security Council may refer a situation to the International Criminal Court as well as stop investigation and prosecution in a situation by deferring it, it cannot influence the outcome of a case. The second principle that I would like to discuss is the presumption of innocence. The principle of the presumption of innocence is a universally accepted standard in human rights treaties and has been adopted almost uniformly in criminal laws and constitutional laws of various states. This principle, which requires that the accused be treated as innocent until proven guilty according to the law, is recognized before all international criminal courts and tribunals. The presumption of innocence requires that the accused has the right to remain silent and may not be compelled to present incriminating evidence against herself or to be forced to confess guilt. The silence of an accused can neither be used as evidence to prove guilt, nor can it be interpreted as an act of admission. The accused has no obligation to give evidence in court, and no adverse consequences should arise from her decision not to testify in her own cause. These rights come from the principle that if an accused is presumed to be innocent, then there ought not to be any duty on her to contribute to the proceedings that are being instituted against her. Additionally, if the accused refuses to enter a guilty or a not guilty plea before the trial chamber, then the trial chamber must enter a not guilty plea due to the presumption of innocence. This presumption is valid until the prosecution establishes the guilt of the accused in front of the chambers beyond reasonable doubt. The burden of proof rests solely with prosecution, and the accused may choose to rebut the evidence presented by the prosecutor, but does not have any requirement to prove her innocence. According to the statutes adopted by the International Criminal Tribunal for Yugoslavia and Rwanda, this principle applies only to an accused. However, there is a general agreement in scholarship regarding its extension to the stages of investigation as well. That is, a suspect may also benefit from it. The Rome Statute of the International Criminal Court extends this presumption to everyone and states that the onus to prove the guilt is on the prosecutor. Now we will talk about the principle of fair trial. The principle of fair trial is recognized in various human rights treaties. Just like the other principles we have discussed today, it has almost near universal recognition and is widely accepted as a rule of customary international law. Fair trial consists of at least three elements: equality of arms, publicity of proceeding, and the expeditiousness of proceedings. The idea of equality of arms comes from the adversarial mode of trial advocacy, which is in the common law tradition. The adversarial model of trial is essentially a contest, a sparring contest between two parties before a referee, that is, defense and prosecution presenting their cases before a judge. The principle of equality of arms makes this contest a fair one by giving an equal opportunity to both the parties and equal rights to both, to make sure that neither party is put at a disadvantage in the presentation of its case relative to the other party. While this principle includes allowing for adequate time and facilities to the accused in order to present her defense without being at a substantial disadvantage vis-a-vis the other side, that is the prosecution, it does not mean parity of material, financial and human resources. The principle of equality of arms in real terms provides the following rights to the accused. 1. That the accused is entitled to know the full charges laid down against her in the indictment. 2. The accused has the right to examine the evidence collected by the prosecution and to be provided with the statements of all witnesses who are to testify at her trial. That the accused, if indigent, is entitled to a defense counsel and an investigator to be appointed by and paid for by the tribunal. The accused has a right to call witnesses and cross-examine them, which includes the right to obtain the attendance of the witnesses by using subpoena powers of the tribunal. The second part, a right to publicity of proceedings, is also part of this idea of fairness. The publicity of proceedings, international criminal courts and tribunals, means that trials are to be held in public in order to ensure fairness and impartiality by allowing the public to scrutinize them. Hearings and the delivery of the judgment takes place in public. However, there are important exceptions to this rule, once again for the sake of the protection of human rights. The rules of procedure and evidence of the ICTY and ICTR provide for the press and the public to be excluded from the proceedings for reasons of public order or morality, for the safety, security, or choice of non-disclosure of identity of a victim or witness, and the protection of the interests of justice. The Rome Statute of the ICC allows closed session trials in order to protect victims and witnesses, or also an accused, and the protection of confidential or sensitive evidence. These measures are particularly implemented in the case of a victim of sexual violence or a child who is a victim or a witness. Trial without undue delay. This is a direct corollary to the presumption of innocence. If the accused is to be treated as innocent until proven guilty, then it is only appropriate to expedite the trial as far as possible and reduce the inconvenience to her by making a determination on the guilt of the accused in an efficient manner. Criminal proceedings in international courts and tribunals have proven to be excessively long due to the extraordinary complexities involved, the collection of evidence, translations, cooperations between states, all of which prove quite difficult. Thus, it is all the more important to have certain time limits. The ICTY and the ICTR have long been criticized for entertaining undue delays in trial. These tribunals have recognized the problem is real and they have set timelines for submission, which is to be made to the court so that the trial can finish in the least possible time. Moreover, these tribunals have appointed additional judges in order to finish the trials in a timely manner. The right to be present. Let us now talk about the presence of the accused. International criminal law makes the presence of the accused essential for the commencement of a trial pertaining to its adversarial nature. Absence of the accused may cause a manipulation of the trial. For instance, in absentia cases have been used in the past to falsely convict and sentence dissenters who are no longer living or living overseas. The importance of the presence of the defendant at the trial has been emphasized by the European Court of Human Rights because this one tool serves the purpose of verification and comparison of the defendant's statement with the ones put forth by the victim and witnesses. States like Spain and Germany, which follow an inquisitorial system, promote this principle and thus advocate and in fact mandate the attendance of the accused at the time of a case going to trial. These are examples of states that consider the right of the accused to be present at the trial to be a paramount human right and reckon it to be uneconomic to hold trials which ultimately do not serve the purpose of justice. Article 63, Clause 1 of the Statute of the International Criminal Court makes the attendance of the accused an elementary requirement for the commencement of trial, with the exception that if the presence of the accused hampers the trial procedure, then it may not be required. Article 5 of the SPET regulations of 2000, amended by Regulation 2001, and Rule 80 of the Extraordinary Criminal Chambers in the Courts of Cambodia also omit trials in absentia. However, the ICTR, the ICTY, and the Special Court for Sierra Leone do not have any special provisions on this matter. They do have provisions for the right of the accused to be tried in their presence. If this right is waived voluntarily by the accused, then it may be construed as a case where the trial may be conducted in absentia. Let us now come to understanding criminal sentencing. Punishment for those who are found guilty of perpetrating crimes is an essential element of criminal justice, be it at the national or the international level. Under domestic laws, the objective behind sentencing have traditionally been retribution, deterrence, the protection of public morality, rehabilitation, and social integration of the offender. Under international criminal law, the primary objectives of sentencing have been retribution and deterrence, with the others being secondary. As the ICTY has noted, the other three aims that sentencing usually promotes, that is, rehabilitation, social defenses, and restoration of civil society, have not yet achieved the same importance as retribution and deterrence have in the sentencing history of these two tribunals, even though there have been opinions of the trial chamber that rehabilitation is an important goal for achieving the ultimate aim of the tribunal. The principle of legality is a general rule of international criminal law. It requires that penalties be enacted before their application. Thus, a penalty should have existed at the time of commission of the offence. This requirement complicates the matter of sentencing under international criminal law because often tribunals are created after an event. In fact, international criminal courts and tribunals, by their very nature, are post hoc. They always take place after the commission of offences in order to meet the requirement of the principle of legality. Tribunals have undertaken several different approaches. For example, The military tribunals at Nuremberg and Tokyo considered that the sentences they imposed are rooted in customary international law, which means that they must have pre-existed the commission of the offence. The statutes of the ICTY and ICTR state that trial chamber shall have recourse to the general practice regarding prison sentences in the courts of former Yugoslavia and Rwanda. The Rome Statute of the International Criminal Court also states that no one shall be criminally responsible under the statute unless the conduct which is being questioned constitutes, at the time that it takes place, a crime within the jurisdiction of the ICC. We now come to the very important question of death penalty, essential aspect of understanding sentencing. The international military tribunals in Nuremberg and Tokyo were authorized to impose death penalties, which they did in several cases. Since then, there have been various developments in international human rights law, especially the movement regarding the abolition or passing a moratorium on the use of the death penalty. While the abolition of the death penalty is not yet universally recognized, the statutes of subsequent tribunals, including the International Criminal Court, do not include the death penalty. How does one determine a sentence? National criminal codes usually provide a tariff of penalties for various criminal offences. However, this is not true for international courts and tribunals. Thus, judges of the international courts and tribunals have a greater discretion in determining the length of a sentence. The ICTY and the ICTR statutes only give rough guidance to a judge regarding the determination of the length and severity of a sentence. For instance, the ICTY statute states that in imposing sentences, the trial chambers should take into account such factors as the gravity of the offence and the individual circumstances of the convicted person. The rules of procedure and evidence of the ICTR and the ICTY additionally tell us that in determining the sentence, a trial chamber shall take into account such factors as aggravating or mitigating circumstances pertaining to the accused or to the context of the case. There is not much clarity regarding what these circumstances might be, apart from the fact that substantial cooperation with the office of the prosecutor by the convicted person before or after conviction is usually counted as a mitigating circumstance. The mitigating and aggravating circumstances have been further clarified and expounded upon in the jurisprudence of the two tribunals. Under the combined jurisprudence of the ICTY and ICTR, aggravating circumstances have been found to include the gravity and scale of the crime, the age, number, and suffering caused to the victims, the nature of the perpetrator's involvement, premeditation and discriminatory intent, abuse of power and position as a superior. While the mitigating circumstances, in addition to cooperation with the prosecutor that I just explained, include the expression of remorse, voluntary surrender, assistance to detainees or victims, good character, imprisonment, age, comportment in detention, family circumstances, and also exceptionally poor health. The Rome Statute of the International Criminal Court limits the imprisonment to a maximum term of 30 years. However, it allows life imprisonment when justified by extreme gravity of the crime and the individual circumstances of a convicted person. In addition to imprisonment, the Rome Statute of the International Criminal Court provides for a fine as well as forfeiture of proceeds, property, and assets derived directly or indirectly from the crime for which the person has been convicted. Let us now conclude. In this module, we first appreciated the fact that procedural rules are judge-made law and govern the action of prosecuting authorities. They provide safeguards to the accused and list the framework for trial. Procedural rules also provide guidance on the sentencing of individuals who have been found guilty by the tribunals, whether they are international criminal courts or tribunals. We looked specifically at procedures regarding independence and impartiality of the tribunals, including independence of judges. We looked at the principles of presumption of innocence of the accused, at fair trial procedure, and lastly, we studied sentencing procedures. In studying sentencing, we looked at the retroactivity of the punishments handed to the guilty, the determination and assessment of the length of the sentence, and the growing trend towards the abolition of death penalty in international criminal justice. Thank you.